everyone for joining today's presentation. I appreciate you taking the time out of your day. Again, I apologize for the webinar going a little awry, but I think today will be valuable to you and bring you some awareness you may not have had, so I'm looking forward to sharing some knowledge with you. My name is Amanda Howard. I'm an attorney at the Florida Healthcare Law Firm, and today I'm presenting Understanding Your Lease Options for Healthcare Practices. A couple of housekeeping items. This session is being recorded, so you'll be able to get the presentation and the slides. It'll be available on the website afterwards. And I see you all have used your question and chat box, it seems, so you know how to do that. But if you have any questions, just pop your questions and I'll try and answer them when we're discussing a specific topic. If I don't get to it then, I'll try and get to it at the end. Of course, you can always contact me, text, email, phone, and I'll give you all my contact information at the end. Okay, but it looks like everybody can hear me now. David, you said you cannot hear anything. You tried calling the phone number, but it seems like everything's working now. Okay, so again, I'm Amanda. I represent healthcare professionals and healthcare businesses. I have a focus on real estate, corporate transactions, and employment issues. I grew up in a family of healthcare professionals. My father, mother, aunts, uncles, cousins, sisters, somebody was a healthcare professional, whether it was a nurse, physician, dentist, orthodontist. And I've seen many of them own their own practices. So I've seen the good times, the bad times that professionals like yourselves go throughout your careers. I, of course, didn't go the healthcare route. I faint at the sight of needles and blood, but I did try and get my hand in it as close as possible, which is why I'm doing what I do. So I attended the University of Florida for undergrad and law school at Loyola Law School in Los Angeles. And now I am practicing with the Florida Healthcare Law Firm, of course. We're based in Delray Beach, Florida. We're actually opening an office in September or October, probably October, November actually, in Tampa. But we work statewide, we work nationwide, and we're a firm of about 12 lawyers. We only work with healthcare professionals and healthcare businesses. Relevant to this presentation, I've spent over a decade in various roles in the real estate industry. I flipped houses, I've done rentals, I've worked in the accounting finance department of a real estate investment company, and then before here, I worked as a commercial real estate litigator. So I linked our firm's website here at the bottom. It's a great resource and it's free. We have blog posts, downloads for checklists, discussion about hot topics, videos. So check it out whenever you have some time. If you have a question, it's probably answered on there. So getting into the heart of the presentation, when it comes to the space in which you run your practice, there's two ways you can do it. You can buy the space or you can lease the space. So today we're going to be focusing on leasing space for your practice and specifically the terms in the lease. So when I'm working with clients, I like to give them, a plan of attack about how we're going to go about this. So the first thing I want to do when I'm reviewing the lease is to make sure that the terms of the LOI made it into the lease and make sure that they're written correctly. Then I'm going to find bad language that I want to try and get rid of or negotiate, and then I'm going to look to see what's missing to add good language to protect you, the tenant. So today you're going to get familiar with some common terms that may show up in your lease for your practice, some that may not be in the lease, some that you should negotiate for, and some you should negotiate away or at least negotiate better terms. So just quickly, we're going to go over through a tenant identity, commencement date versus rent commencement date, rent escalation, use clause, exclusivity clause, expenses and maintenance and repairs, subleasing and assignment, death and disability clause, force majeure, relocation clause, right of first refusal, options to extend the lease, and then a personal guarantee. So these are not the only things that you need to be on the lookout for, but they're often the ones that have the most impact on your tenancy. So it's important to be aware of them and have some sort of idea about what they mean and how they affect you. So every lease is different. As the tenant, typically you're not going to be drafting the lease, or your attorney won't be drafting the lease. The landlord will typically give you a lease they've drafted for your review or your attorney's review. And unless you're leasing a huge commercial building, which is not so typical for healthcare professionals, leases may be written sort of unprofessionally. They may be hard to read and understand. They may not, follow a flow. And then on the other hand, they may be super simple and not address everything that we want them to address. So just like every lease is different, every tenant has different needs. So you may not need some terms that another professional may need. So for example, if you have a practice with 5 providers, you're not going to need a death and disability clause. It might not be so important. Or if you rent, a single space, you're not a tenant in a multi-unit building, you wouldn't need an exclusivity clause. So I know you might not know what these terms mean yet, but we're going to go over them today, and then I think what I just said will make a little bit more sense to you. Okay, so tenant identity. So the tenant should always be a business entity. It should never be in your personal name. I'm not going to go into detail about this, but proper entities prevent you from being personally liable under the lease. So always make sure that you form a business entity, and that's the tenant under the lease. And then another sort of side note, but something that I've seen come up a few times is sometimes tenants will just sign their name under the entity. That could actually attach personal liability to you. There's some case law on that. So always make sure that you're signing on behalf of the entity, as the authorized representative, and not in your individual capacity. Okay, the commencement date versus the rent commencement date. So the commencement date is when the landlord delivers the space to you, how they're supposed to, when you take possession of the space. So in other words, it's when the lease term begins. The rent commencement date is when payment of rent begins. So going back to the commencement date, the landlord's supposed to deliver a gray shell to you, meaning the space is totally bare for the most part, or in a vanilla shell, meaning the bones are there. That'll be the commencement date. That's when the landlord delivers the space to you how they're supposed to. So the CAD and the RCD, they may be the same, but sometimes they might not be the same. So they wouldn't be the same if you've negotiated, time for your build out, for example. Typically as a tenant, we want to achieve a delayed RCD. We need to build out our space. We need closed patient rooms, cabinetry, equipment. We need technology installed for the equipment, etc. So if you need to build out your space, you don't want to start paying rent the day you take possession, right? Because your business isn't generating income at that point. So we always want to try and achieve a delayed rent commencement date. So a couple examples here. Let's say you have a 10-year lease term. Your commencement date and rent commencement date are both the same, September 1st, 2022, but you've negotiated free rent of 3 months. So even though you're supposed to start paying rent on September 1st, 2022, you've negotiated free rent. So you'll really start paying rent on 12/1/2022. Or let's say you have a term of 7 years. You have a commencement date of September 1st, 2022. That's when you get in there. That's when you take possession. So you start your build out. You've asked to have 4 months for your build out without paying rent. So you start paying rent 4 months later on January 1st, 2023. So this is something to just be aware of. What's the best option for you just depends on what you need. So it's something to be aware of and try and negotiate if possible. Moving on to rent escalations. In any lease, there's going to be some sort of monthly fixed rent. Sometimes it'll be called base rent, monthly rent. There's a variety of different terms for it. But either way, there's typically some sort of monthly fixed rent. What becomes important is when that increases, it'll typically increase year over year. And there's a couple different ways that it could increase. So the first way is through fixed percentage escalation. So the amount you pay monthly might increase by 2 or 3 or 4% year over year. This is often the best choice for tenants. It's, there's no surprises. It's a locked-in rate. So you could have a lease term of 10 years and you'll know exactly what you're paying 10 years from now. The second option is escalation according to the CPI. The CPI is the Consumer Price Index. It essentially, is a measure of inflation. And each sort of geographic region has a CPI. So it'll just depend on the region you're in to what sort of percentage applies. But tenants often find this as the worst option. It's pretty unpredictable. If inflation rises, then so does your rent. On the other side, if inflation doesn't rise, then you could have minimal increases. But as we all know, we're suffering from inflation right now, and landlords may want to tie your rent to the CPI because it is on the rise. So that's just something to be aware of, especially now currently. Third option is a hybrid between the CPI and the fixed. So if the CPI reaches a certain benchmark, maybe your year-over-year will increase by 4 or 5%. Or if the CPI goes below a certain benchmark, maybe it'll only increase by 2 or 3%. So of course, we can't predict the future. So maybe the CPI will drop in future years. I categorize the first option, the fixed rate, as the less risky rate, and the CPI as the more risky rate. It's just something to be aware about. Determining what's best for you and your business just takes playing out some scenarios. And you can do that yourself, your accountant, your financial advisor, or attorney. So just something to be aware about. Okay, moving on to the use clause. The use clause describes what services you can provide and what activities you can do in your lease space. So as a tenant, we want the clause to be, as broad as possible because we don't want to be limited in what we can do in our space. On the flip side, the landlord wants it to be as narrow as possible. Failure to comply with this sort of term, typically under the lease, it'll typically say that if you don't comply with the use clause, you'll be in default under the lease, and being in default under the lease means that the landlord can terminate the lease typically. The use clause ties in heavily with the exclusivity clause, which we'll talk about next. And it also ties in with subleasing and assignment. And we'll look at some examples of this right now. So let's say you are, actually we'll look at an example of how this affects subleasing right now. So if you're a dentist, and let's say that you want to sublease to an orthodontist. Maybe that's not very practical, but maybe you want to sublease to an orthodontist, a little piece of your space, become a one-stop shop. Everybody can just come to you for everything. So let's say that your use clause says that you can only use the space for general dentistry only. So this sublease to the orthodontist wouldn't work, right? Because orthodontics isn't general dentistry, it's a subspecialty, it's something else. So of course you can always go to your landlord and try and negotiate this, You can say how it'll be good for the business. But just looking at this simple clause, just to keep things basic, if we're looking at this clause, we wouldn't be able to sublease to that orthodontist. And let's say that you are a dermatologist, and maybe you want to do Mohs surgery, and your use clause says for cosmetic dermatology only. So again, you likely wouldn't be able, without getting, consent from the landlord, to do Mohs surgery in here because Mohs surgery, is a different beast. It's bigger than cosmetic dermatology. It requires different equipment, different spaces. There's different regulations for that. So this is so knowing what's in your use clause and negotiating a broader use clause is super important. You don't want to be limited by the use clause and what you can do. And like I said, the use clause ties into the exclusivity clause. So this clause prevents the landlord from leasing space to another potential tenant in the complex that would use their space for the same use that you use your space for. So, let's say that you're a dentist and you don't want any other dentist being in there, right? So that's what this exclusivity clause would do for you. So this typically arises in multi-tenant complexes or spaces, not single-tenant buildings, because if you're in a single-tenant building, right, there's no other competition that the landlord could rent to. And it's more common in retail spaces. Landlords will be more likely to give you one of these. It's not so common in professional office buildings, right, because it's an office building of professionals, so you're all doing the same thing anyways. So landlords don't love to agree to this clause, and I'll just tell you right now, you're never going to see this clause. You're never going to be given a lease with this clause in it. Your landlord will never present this clause to you. You're always going to have to propose it to the landlord. And they don't typically, love to agree to this clause because it could prevent them from getting an attractive tenant in the future, right? So by giving you this clause, they're giving up an opportunity of having another attractive tenant come in the future. So negotiating this just depends on the circumstances, what you bring to the table. And as expected, a landlord is going to be more likely to agree to this if the clause is narrow in scope. So we're going to look at some examples of this now. All right, so let's say you are a dermatologist. And I apologize if none of you are a dentist or dermatologist. These are just the two examples I've chosen for today. But they apply. You can think of how you would like it to be written. So let's say you're a dermatologist and you present this clause. The lessee shall hold exclusive rights to operate on the premises with the following uses: skincare. So if you present this to the landlord, you're basically saying that nobody else, you can't rent space to anyone else who does anything with skincare, right? You want to have a monopoly on it. So the landlord probably isn't going to like this clause. It's too broad. Many other people can be in the industry of skincare. So you could have a med spa, an esthetician, whatever it may be. So the landlord probably wouldn't like this clause. But let's say you are a general dentist and you propose this second clause. The lessee shall hold exclusive rights to operate on the premises with the following uses: general dentistry. So this, your landlord probably will agree to. It doesn't include orthodontics, periodontics, oral surgery, other dental specialties. It's narrowed in scope, even though it says general, it's narrowed in scope to the specialty. So just always try, again, depending on the location, you may or may not need this. If you do, present it to the landlord, always try and narrow it in scope. Expenses and maintenance and repairs. So these are just super important to be aware about because, they're added cost to you. So you need to know before you sign the lease what you're responsible for, how much it's going to cost. Generally, there's two types of leases, a gross lease and a net lease. There's tons of different variations under both of these, but for our purposes, we're just going to stick with, the basics, a gross lease and a net lease. So a gross lease is when you pay one fee. So it's all expenses packed into one. So let's say you pay a fee of $5,000. So that'll include, your lease of the space. Maybe it'll include water, sewer, trash, electricity. You just pay one fee. This isn't that common. You may see this, but it's usually with unsophisticated landlords or, single tenant buildings. What you're more likely to see is a net lease, and you're most likely to see a triple net lease. So a net lease is multiple costs that you have to pay. So you'll have an amount for base rent, which again is, the price you're paying to lease the space. And then on top of that, you'll have monthly charges for expenses, like maybe your electric, sewer. So it's added on, it's not all packaged together. So this is the most common, a net lease is, and then a triple net lease, the most common. So with this, you pay for your share of landlord's proportionate, or your share of landlord's property tax, insurance, and common area expenses. So if you're in a building that's 10,000 square feet and you occupy 2,500, you're going to be responsible for 25% of the landlord's property tax, insurance, and common area expenses. Both of these types of leases may allow for reconciliation. So, for example, if you overpay on some expenses, your landlord can refund you. And if you underpay, you may have to give more. That's just something I wanted to bring to your attention. This is all kind of negotiable, and it all just depends on what the landlord presents you with. At the end of the day, under both of these types of leases, you're paying around the same. It's just packaged differently and it's presented differently to you. Moving on to maintenance and repairs. So it's important to know who pays for this and who performs it. And again, it depends on the lease, but for example, you could be responsible for just maintenance. So a common term that we'll see is the tenant's responsible for HVAC maintenance. And typically what that means is they need to contract for a quarterly service on the HVAC unit to make sure, that it's working good, stays up and running, because replacing it is super costly. On the other hand, your lease could say that you're responsible for maintenance and repairs. So you could, in the end, be responsible for replacing the HVAC, the roofs. These are all very expensive, big ticket items, generally not negotiable. So you need to be aware of this. You need to know what you're responsible for and, see if that works for you. Okay, moving on to subleasing and assignment. Okay, so I actually just heard this a couple days ago, this sort of analogy, so you all can tell me if this makes sense to you or not. So I'm just going to explain what a sublease and assignment is. So an assignment is when you have your physical lease in your hand and you hand it to somebody else, right? They're standing in your shoes, they're taking your space for the rest of your term. Just a side note, under an assignment, you, the tenant, are generally still going to be liable. So if the assignee defaults, if this new tenant, doesn't pay their rent, the landlord can go after both of you. So that's something to be aware about, and we'll touch on this a little bit more at the end of the presentation. So that's an assignment. A sublease is when you hold your lease paper, but then in another hand, you make a new contract and you give it to somebody else. So a sublease is when someone leases a portion, just an area of your space, or for some period of the term. So it's not for the whole term. So they're not standing in your shoes. They're kind of like an addition to you. So when do we see these? We see a sublease when there's like a specialty or another entity that works in conjunction. So going back to that dentist orthodontic example, let's say you want to sublease to an orthodontics, you're a general dentist, you want to be a one-stop shop, so maybe you want to sublease. So we want to get language in the lease so that you can do that. Another one is works in conjunction. So let's say you're a dentist and maybe you make your own teeth, so you have another entity that's a lab. So maybe they lease some, they sublease some space. So that's why sublease would be important. An assignment, generally in the healthcare field, is important when you sell your practice and upon the unfortunate event of death or disability. You want to be able to hand the lease and the obligations they're under to somebody else. So clearly, these are important. And there's always typically going to be some sort of clause in the lease about subleasing an assignment. But we want, as a tenant, the clause to say that we can sublease and assign to whoever we want and whenever we want. Unfortunately, that is never going to happen. And actually, oftentimes, the lease will say that that consent to the assignment or the sublease is at the landlord's sole discretion. So that's really subjective. So, let's say that you want to assign the lease to somebody, to another dentist, and the landlord just doesn't like their name. Well, if this clause was written into the lease, landlord's sole discretion, then they could just not consent to the assignment because they don't like the lease. It's not based on anything objective. It's not something that everybody could agree upon. So we don't want the lease to say in landlord's sole discretion. We want to put a more objective standard in there. Generally, something that we can negotiate is, it's called a permitted transfer. It may be called something else, but this is generally what it's referred to as. And a permitted transfer just says that you can assign or sublease the space without the landlord's consent in certain instances. So an example of that would be if you want to assign the lease to a successor, to a parent or a subsidiary entity, an entity to which all the tenant's assets are transferred. So this new entity is essentially you. An entity or person with a better financial status or creditworthiness, or in the event of death or disability, or in the event you sell a practice. So there's a variety of different permitted transfers, different ways to give a landlord less control. Another thing to look out for in the sublease assignment clause is how long it takes for the landlord to respond, to give the consent or to not give the consent. So, if it says that you can present the sublease or assignment to the landlord and they have 100 days to respond, that's probably not going to be good. The person who's subleasing or assigning the space isn't going to want to wait around that long. So we want to make sure that the timing for the landlord's response is a shorter period. And then another thing I wanted to bring your attention to, the recapture clause. I've never seen this used and I haven't actually heard of it being used, but a recapture clause basically says that if you present an offer to sublease or assign, the landlord can terminate the lease. So it's important to be aware of that, even though it's not practically used, important to be aware of. So let's look at an example. So again, like I said, we don't want consent to be based on the landlord's sole discretion. So a way to get around that is to write a clause like this. Lessee shall not assign this lease or sublease, any part therefore, without prior written consent of the lessor, which consent shall not be unreasonably withheld, delayed, or conditioned. Notwithstanding the foregoing, lessee may assign this lease or sublease, any part therefore, pursuant to a permitted transfer. Right, so the second sentence we just went over. This is when we don't need consent, we can just do it and we're good to go. Going back to the first sentence, this is a language we want to see, right? This means that the landlord can't be unreasonable. It's an objective standard. So again, the landlord can't say no to the assignment or sublease just because they don't like the name of the sublessee. A more objective standard would be if the assignee wouldn't personally guarantee the lease and you're released under it, or if they're in bankruptcy, right? That's a more objective reason to deny consent. So subleasing assignment is a big thing. Again, we want anything besides landlord's sole discretion for this. Moving on to the death and disability clause and insurance. So a death and disability clause allows you as a tenant to be released from the lease and all the obligations they're under in the unfortunate event of death or disability. As a side note, as professionals, you may have insurance that cover your overhead expenses for a period of time. So this sort of insurance will typically cover rent, right? Rent under the lease, payroll, management fees, and it'll typically be for 12 to 24 months. But let's say that you're, in your first year under the lease, something goes wrong and now you have 9 years left. So maybe your insurance will pay for those expenses for the next, 1 to 2 years. But if you can't get someone to buy the practice or otherwise assign the lease, you're obligated under the lease and you're going to be responsible for all the rent and, performing the obligations under the lease for those next, 7 to 8 years. So we want to get a death or disability clause to release us from the lease and those obligations. This is particularly important if you are a solo practitioner or a primary provider. So in both of those instances, you as a single person is typically bringing all the business to the company. Without you, it wouldn't operate. If you remember at the beginning, I gave you an example if there's like 5 providers, maybe you all do the same thing. In that sort of an instance, a death and disability clause isn't as important because, there's not only one person responsible for all these obligations. Typically, to get one of these clauses, it requires a buyout. Usually, you'll have to give a certain amount of months, you'll have to pay a certain amount of months rent, and you'll have to give a certain amount of notice. So again, this is super important if you're a solo practitioner or a primary provider. It protects you, it protects your spouse, your family, and your estate. So this is one of those clauses that may not be applicable to you, but if it is, it's super important to try and negotiate. And here's the example. It's a lot of words, but bear with me. Upon the death of a majority of the members of the lessee, the personal representative of authorized members' estate may terminate this lease upon 30 days written notice to the lessor. If during the term of this lease, a majority of the members of lessee, by reason of physical or mental impairment, are no longer able to perform in all material respects the usual and customary professional duties of lessee, then lessee or lessee's personal representative may terminate this lease upon 30 days written notice. So again, that was a lot of words, but it was pretty simple, and you may not see something so simple like this. Maybe so. It's pretty tenant favorable. It doesn't require a buyout, just 30 days notice and you're under the lease. But all it's saying is that if you die or if you have physical or mental impairment, you can get out of the lease. So this is just to show you that, there's ways to get out of the lease. A force majeure clause. A force majeure clause is a contract provision that relieves the parties from performing their contractual obligations when certain circumstances beyond their control arise, making performance impracticable, illegal, or impossible. So this clause became a huge deal during COVID. So if a government says you can't run your business, and I know this wasn't as prevalent in Florida, but California and New York, for example, businesses were shut down for a long period of time. And also during COVID, I think even in Florida, a lot of elective procedures were paused. So if you, because of a government directive, can't open your business, all you do is maybe elective procedures. it's impossible to generate income, right? And it's difficult to pay rent. So a lot of tenants, especially during the height of COVID, tried to rely on this clause. However, most leases only release performing acts, not the payment of money. So unfortunately, this didn't work out for a lot of tenants, and they had to stay in their lease even though they were trying to get out. So for example, most leases say that the tenant has the obligation to operate its business, right? It has the obligation to stay open, make money. That's why the landlord brought this tenant in. Well, if you can't because of a government directive to, keep the office closed, you wouldn't be held to that. So you wouldn't be in default under the lease, and the landlord wouldn't be able to terminate the lease. However, you'd still be obligated to pay rent. So it seems kind of unfair, right? Like, I can't stay open, I can't make money, yet I'm still obligated to pay rent. So this is an example of how to try and get around that so it's not so unfair. Or this is an example of a bad force majeure clause, and then I'll talk about how you can try and get around it. So if either party hereunder shall be delayed or prevented from the performance of any act required hereunder by an act of God, war, insurrection, pandemic, strike, or any other unforeseeable event, a force majeure event, then performance of such act shall be excused for a period of delay and extended for a period equivalent to the period of such delay. However, this subsection will not excuse or delay the payment of money by either party. So let's dissect this. So we see that an act of God, war, insurrection, pandemic, strike, anything that's unforeseeable, not in our control, that's going to be a force majeure event. And during a force majeure event, we don't have to perform, any act. So again, we don't have to stay open because the government says we can't. However, we still need to pay rent. That's not excused. So I have a couple suggestions. Of course, I would always try and get rent totally abated, right? So you don't have to pay rent, you don't even have to pay it back. It's totally free for these certain months while the force majeure event is happening. That is never going to happen. A landlord would never agree to that. So instead, a suggestion would be to suspend rent. So let's say there's a force majeure event for September and October. So maybe you don't pay rent in September and October, but over November, December, January, February, so over 4 months, you repay back that September and October. So, lightens the burden on you so you don't have to pay it all at once. It's over, kind of a payment plan. Something else you could do is you could request that base rent be suspended, right? So that's the fee for leasing the space. So if you can't get in that space, you can't use that space, should you really be paying rent for it? As a tenant, we don't think so. So maybe you could say that base rent is suspended, abated, or discounted. Any sort of thing you can get. But we'll offer that we'll still pay operating expenses. So we'll still pay the insurance, the tax, the common area expenses, whatever they may be. So there's tons of ways to get creative under this. Really depends on, what you want, what you need. And, your landlord may not be willing to budge on this, but it can't hurt to try. Okay, a relocation clause. A relocation clause allows a landlord to move you to another space in the complex of the building, whether you want to or not. So generally, I like to get rid of this entirely, right? We don't want to move. You're healthcare professionals. You pick this space for a reason. Maybe you did a really intense build out, especially in healthcare, you need certain things that, typical retail clothing store wouldn't need. So we don't want to move. So like I said, generally, I try and get rid of this clause entirely. If that doesn't work, the landlord won't agree to that, then we want to ensure that the lease says that we'll be moved to a similar space, right? A similar size. So if you're in a 5,000 square foot space, you're not going to be moved to an 1,000 square foot space, right? You need to make sure it's, similar and equivalent. And in addition to that, we want the landlord to pay for all relocation costs. So maybe you did a build out in your current space, but the landlord's going to need to pay for the build out in the space they want to move to. If you need to deinstall things, reinstall things, they need to pay for the relocation of furnishings and equipment. And then something that tenants might not typically think of, but if there's any interruption in your business, we want to recoup that, right? So if we have to close down and we can't get in that new space for a month or two, we want to be compensated for that in some way. And then another thing I'll say about this is Sometimes tenants may want to use, their own contractor or, their own team to do this new construction. But as professionals, you may need people who, specialize in this. So maybe you need to be able to choose the dental designer, architect, builder. While the landlord wants to choose, their architect and builder for the lowest cost, you need someone who does this work every day. So even if it's not the lowest cost, you want to make sure that it's written in your lease that you have, that it's your choice to pick whoever the designer, architect, builder is. So again, try and get rid of this. If you can't, make sure the landlord is responsible for everything. Okay, the right of first refusal. This gives you, the tenant, the right, not the obligation, to purchase the property first in the event the landlord receives an offer to purchase the property from a third party. So, this will generally be for a single space or just a couple of spaces, not in a huge building. As a healthcare professional, you're probably not going to purchase a huge high-rise with tons of other tenants in it. But, it could be important if it's a single space or if there's, a space next to you. Maybe you want to expand in the future. So, as a healthcare professional, you are pouring your blood, sweat, and tears into your practice. The space is the nucleus of your practice. It's how your practice, is alive. So, maybe you think down the line that you'll want to purchase the property for an investment purpose, or maybe you want to have, more control over the space, or maybe you don't want to risk the landlord selling to somebody else, to a new landlord who may try and kick you out, or just, may do things in a way you don't like to do. So having one of these clauses just gives you the chance, right? You don't have to buy it, but it gives you the chance to purchase the property if you choose. And if you have any inkling that this will be important to you, then you should try and negotiate this. Here's an example. If during the term of this lease, lessor receives an offer from a third party to purchase the premises, lessor shall give written notice to the lessee of such offer, including the offered sale price and all material terms. Provided lessee is not at such time in default, lessee shall have the right for 15 days from the receipt of such notice to notify lessor in writing that it elects to purchase the premises under the same terms and for the same sale price as contained in the third party's offer. So again, I know this is a lot of words, but this is typically how leases are written. They're confusing and not as simple as they could be, but all it means is that if the landlord gets a written offer from somebody, they got to present it to you, and if you want to buy the property on the same material terms and on the sale price, and on the same sale price, it's yours. So again, depending on your future plans, try and negotiate this. And I know we're nearing 1 o'clock, so if some of you have to leave, no worries. I apologize. I'm kind of going a little bit faster than I wanted to because you could not hear me for the first 20 minutes, which again, I apologize for. Moving on to options to renew the lease. So it's important to know when you can exercise this and how you must exercise it. So, and just going back a little bit, never sign a lease without options, right? Because without an option, your lease could end and you've done all this build out, you've established your practice, and you can be kicked out, right? So if you sign a 3-year lease, you've done all this work and you're kicked out, it's probably not what you want. So then going back to when can you exercise, how much can you exercise? You typically have to exercise by written notice, and you must give that written notice. It depends, but generally it would be 6 months before the expiration of the lease term. So let's say that you only give notice 4 months, not 6 months. So you didn't exercise it properly. So at this point, the landlord has leverage, right? Maybe they'll kick you out, or maybe they'll say, hey, instead of renewing all these terms we already agreed to, we gotta renegotiate and pay above market rent now. So it's important to know when you must exercise and how you can exercise it, because if you don't, and you're, technically, or if you don't exercise it properly, it doesn't exist anymore, right? The landlord can give it to you or cannot give it to you. And just a couple notes about this. If you're in default under the lease, there typically will always be a lease provision that says if you're in default under the lease, then the landlord doesn't have to give you this option to renew. So be aware of that. Another thing is these are typically personal to you, the tenant. So if you assign the lease to somebody else, they're not going to have that same ability to renew the lease. They're not going to have those options. And this is always a good time to try and renegotiate. If there's something you didn't like, something you want to get, always take the opportunity to renew the lease to, try and get the terms you want, try and renegotiate. All right, on to the last big thing, the personal guarantee. So personal guarantee allows the landlord to seek payment under the lease against you personally. So I know a lot of professionals have concerns about this. They've told me personally, and rent for healthcare practices can be hefty. So, you don't want your personal assets to be gone after by the landlord. So this can be really scary. But this is super common, 9 out of 10, probably even more than that, you'll see this, but you should always try and negotiate it. So there's a couple different things you can do, and more things than what I'm just going to tell you, but you could try and get it limited for a period of time, right? So let's say you propose this to the landlord. If you're not in default for the next 3 years, then you'll be released from personal guarantee, right? That would be a way to do it. Or maybe you only have to personally guarantee the lease for the first term, the initial term, which is 5 years, and maybe you have 2 5-year options, so that's an additional 10 years. So maybe you'll be on the hook for the 5 years, but you can get out for those 10 years. Another one is to cap it at a certain amount. So let's say that your monthly rent's $5,000 a month. So over 24 months, that'd be $120,000. So maybe you say, I'm only going to be liable for $120,000. So you can try and cap it at a certain amount. Another big thing is to try and get released upon assignment. So again, if you assign the lease, that person standing in your shoes, you don't want to be responsible for them. The landlord consented, presumably, so why should you still be on the hook? So we want to make sure that we're released upon assignment. Something I just did want to bring to everybody's attention so it's not so scary and so you can have some peace of mind is in Florida, and I'm sure tons of other states, there's certain things that creditors can't go after. So, the landlord couldn't go after your primary residence, your homestead. They couldn't go after your wages if you're the head of household. They can't go after disability income, retirement accounts. There's a bunch of things that they can't go after. So, while it seems like they can, take you for all you're worth, there's some things that they just can't go after. So it's best to talk to an asset protection attorney or debt attorney about this, but I know it's scary. There's ways to get around it, limit it. And so you should always try and negotiate for that. So here's our last example. Bob Smith hereby personally guarantees payment and performance of the obligations under this lease for the initial term of the lease and any renewals or expansions. So we don't like this. And I was going to ask some of you to maybe type in the box why you think this isn't the best. Since we are super short on time, I'll just go ahead and tell you. It goes on indefinitely, right? It goes on for the initial term, any renewals or extensions, could presumably go on for forever if you end up having a 99-year lease. Another thing is there's no cap on the limit. So you're obligated for all the payment under lease at all times. There's no cap. And another thing it says, another thing is that it doesn't matter if you assign the lease, you're still going to be liable, right? Because it says Bob Smith guarantees payment and performance of the obligations under this lease. So it doesn't matter if the tenant changes, you're still going to be responsible. So to wrap things up, to understand what's in your lease, you're going to have to read it over a few times. Typically, they're not the easiest things to read. To understand how those terms affect you, what's reasonable, what's missing, you should have a professional review your lease. I want to thank everyone for coming. I really appreciate you being here. I hope you learned a few things that maybe you can have in your back pocket, or maybe I just brought some awareness to things you didn't know. So when you see some of these terms, you can have a better understanding of what they are and what they mean. So again, I'm Amanda Howard. Here's my contact info. You can email me at ahoward@floridahealthcarelawfirm.com. Text or call me. That's my personal number, the 239-898-7794. Does anybody have any questions? I'll wait a couple minutes to see if you guys pop anything into the question box. In the meantime, again, it's actually funny because I was talking to myself for 20 minutes, so I'm glad. Who was it that spoke up? Steven or Stefan. Thank you for bringing that to my attention. I'll hang on a few more minutes if anybody has any questions. Feel free to type them in. Otherwise, have a great rest of your day. All right, it doesn't look like anybody has any questions. I can definitely hang on for one more minute if anybody wants to type anything in. And again, feel free to email me or call me, whatever you prefer. All right, thanks everybody. Have a good day.